I'm glad to introduce you in a certain way to the Price Media Law Moot Court Competition, International Media Law Moot Court Competition. And I want to talk a little bit today about the overall significance of this competition and how to think about it and how, in part, to prepare for it in a very general way. If you're engaged in it, you'll be very intimately involved with materials dealing with media law and policy. So it's useful to have a broad overview of how to enter this very critical and important space. The first thing I'd say is that all the problems in this moot court competition are about a very significant phenomenon, and that is the power of the message, the power of information, for good, for democratic values, the power of information in a way that hurts people, that destabilizes authority, that does so many things. And in a certain sense, law is about the relationship of regulation to power. It's about how much the state should be given authority to limit the exercise of great power. And so here we have the great power of the message, which is seen everywhere in your society and other societies. So it seems to me you've got to keep in mind this great polar question of power and regulation, power and stabilization, power and democracy. In thinking about it, it seems to me you can turn then to various sources of information. And one of the things is how to conceptualize the sources of information and how to sort of develop a program of thinking about this basic question. The Oxford program has created an international media law reference database, and it's online, and it's available in addition to many other sources. But I want to talk a little about this International Media Law Information Database. So it has established categories of information which are a little bit like categories of thinking. So the first one is theories of free speech. In a lot of ways, this whole field has been sort of categorized by a notion of what does it mean to have free speech in a society. We have international covenants and agreements which commit societies to free speech. And the question which you'll come up against time and again in preparing for this moot court is the idea of free speech, what its limits are, what it means, and how it constrains the state. We can then turn to another area which I think is very important and increasingly important, and that is free speech and privacy, or privacy, depending which part of the world you come from. So here, the literature is burgeoning but significant. Many of the problems that we've used in the moot court competition deal with the use of the state's power and state's machinery to inquire into people's lives, to gather information about them, to create great databases which can be of use to the government. The area of free expression and privacy is really about the limitations that exist or are thought to exist on government's capacity to engage in this kind of surveillance. So this becomes a looming and bigger issue and occurs very frequently in the course of the discussions about moot court problems. A third area in this international media law database is technology and speech. The first category is about free speech, about privacy, or about thinking, jurisprudential ways of considering this area. But you'll see that technology becomes a kind of key in a modern world of thinking about this as well. So you need, as you prepare for this, to try to think about the role that technology plays or should play. And I think in doing that, you'll have a greater insight into the overall way of articulating and understanding these media law issues. This international media law database also contains a number of judicial decisions. One of the things that was very interesting in putting together this database was how to accumulate materials not only from the Western society, but from all kinds of society, from China, from India, etc. And this is a very great challenge, and I encourage you when you're doing research to think about a whole variety of perspectives, not to take one perspective as for granted and assume, but to try to think of other perspectives, even if you don't invoke them, so that you understand them and come to a deeper and richer understanding of the basic concepts, etc. In looking at the kind of courts that these judicial decisions come from, this is also a very important element, which is to think about how courts are very different, how they pose questions differently, and how they frame the issues in a way that should influence a person arguing one side or another. So you have the European Court on Human Rights, you have the American Supreme Court, you have the Inter-American Court, you have international conventions, and all of these are basic fundamental documents that will frame your discussions. So there's a rich area of discourse, there's great materials, there are issues of substantial importance as every society flourishes, and as it's determined whether speech can perform a great, incredible role in furthering democracy, and how it weaves its way through problems posed by governments and by new technology. Thank you.